Welcome to this episode of Estate Planning Secrets Revealed. My name is Attorney Tony Bell, and today, in this episode, we are going to look at intestate succession and dealing with probate without a will. Intestate succession and dealing with probate without a will. So, what happens if your loved one has passed away and no one could find a will and there was no will? Well, that is called intestate succession. And when that happens, probate still happens. The estate as a whole still has to go through probate, but it goes through probate as an intestate estate. And so what happens then is when there is no will to guide the direction of the distribution of assets, the court then takes on the role of the central role in this distribution and in this process of probate. The first thing that they will do is they will find someone who will administrate, and they will be the personal representative for the decedent. Many times this is a family member, or it could be just someone else, depending on the dynamics of the family and what's going on. If there is no will, and if the court has deemed that this is intestate, then the distribution of assets has to happen according to the state laws, as opposed to what the decedent may have really wanted. Since the decedent had no written will and didn't take the steps to create a will, the state and the state laws for intestate succession take precedence. And so usually preference is given to the immediate family, the spouse, and then the children, and it goes from there. However, it can cause a lot of problems and a lot of strain on familial relationships. In the absence of a will, the administrator is usually, as I said earlier, a close family member, or another individual who has a vested interest in the estate. Probate, which is the legal process of settling an estate, takes on a really unique dimension when there is no will. And the absence of clear instructions that a will would provide really can lead to challenges and potential disputes among family members. It happens all the time. The process involves identifying the deceased person's assets, valuing the assets, paying off debts, paying off creditors and taxes, and then after all of that, then distributing what remains to the rightful heirs after everyone has been paid. It is a very structured process, but without a will, it still can become even more complex and time-consuming as well for everyone. Dealing with probate without a will can present challenges. Disagreements among family members, delays in asset distributions, uncertainties about the deceased person's intentions can all arise when there is no will. So seeking legal guidance during this time is really important, because an attorney who deals with probate, they are experienced in this. They know how to help you to maneuver through this time and how to maneuver the courts and get everything done. So I would highly recommend that you find an attorney who can help you through this time and through the probate process. going through probate without a will is not fun at all. However, it can happen, and it does happen quite a bit. Hopefully, if you are seeing this, you have put together your will and also an estate plan in order to help others to not have to go through this. If you are on the other end of it and you are trying to probate an estate where there was no will, feel free to contact an attorney who can help you. But either way, know that it can be done. I'm attorney Tony Bell. This has been Estate Planning Secrets Revealed, and join me in upcoming episodes where we will continue to delve into the secrets of estate planning and how you can create a lasting legacy for your loved ones. See you soon.